So let's look at these facts. I'm just going to run you through that first paragraph. Fort Myer contracted with the DPW, and this whole thing about the facts of this particular case. These are especially hairy because it involves an employment structure, and it also involves a series of agreements and contracts. And so he's got to explain all of that and then explain the fraud on top of it. And that's really complicated. Fort Myer contracted with the DPW to repair and resurface roads of the District of Columbia. So the first thing is Fort Myer contracted. Using funds provided largely by the Federal Highway Administration, the district paid Fort Myer. I'd like you to do something. I'd like you to underline Fort Myer once and contracted twice, and we're gonna talk about this later. Then I'd like you to underline the district once and paid twice, because we're going to start looking at why this is so clear. How did he achieve this? The district paid Fort Myer based on the weight of the asphalt it delivered. So based on the weight, in amounts ranging from $38 to $50 per ton. So it tells you that the district paid on weight and then how much per weight. So you've got the basic fee structure, pay per weight, and then you've got the specifics. Here's the exact amount paid per ton. The amount of asphalt delivered, okay, so here we're going to underline amount once and asphalt twice. The amount delivered in each truckload was recorded on an asphalt ticket, which a Fort Myer employee gave to a DPW employee. So you start out with the overall view of the contract, what the payment amount was, and then the fact that the amount, which you know is paid for at $38 to $50 per ton, is recorded on this asphalt ticket, which a Fort Myer employee gave to a DPW employee when the asphalt arrived on site. So you're introduced to the asphalt ticket, and you see the asphalt ticket passing from the Fort Myer employee to the DPW employee. Then we've got, at the end of each day, relying on the asphalt tickets, a DPW inspector prepared an inspector's daily report. So you've got Fort Myer employee to DPW employee, and then the DPW inspector prepared the inspector's report, which recorded the total weight of asphalt delivered to the job site. After the data from the IDRs was entered into a computer, the inspector's daily report, the DPW prepared a voucher that authorized payment to Fort Myer for the asphalt and paving work. So he takes you through that process step by step in order, very clearly in a way that you can follow. The point of this is, hold on. The point of this is that at some point there were bribes, and the way that the bribes were accomplished had to do with that paperwork and sort of that chain of custody. It's really tempting to start with the fraud and to start with the bribes and back into how the whole system works, but he didn't do that. He started at the very beginning and walked you through it so you had an understanding of the process. Okay, some other things I want you to, the amount delivered. The next sentence, at the end of each day, relying on the asphalt tickets, a DPW inspector, underline that once, and underline prepared twice. Then after the data from the IDRs was entered, the DPW prepared. So underline the DPW once and prepared twice. Then we're going to go back. Hold on. And the second sentence, you're going to circle using funds. In the fourth sentence, you're going to circle at the end of each day. And in the fifth sentence, you're going to circle after the data. So here's how he achieves that clarity. And this goes to not just the overall, we're looking at the overall document organization. It starts with procedural history, goes to the issue, goes to a roadmap, and then goes to the facts, starting with the indictment and then leading into the evidence. And as he starts to describe this very complex evidence, there are three things he does that really make this paragraph very clear and accessible. The first is he does it in order. He doesn't start with what the defendant did wrong. He starts with the process that the defendant mucked up later. Okay. The second thing he does that makes this easy to read is he uses active voice. And there's a strong subject and an action verb as the core of every single sentence. And that is the most deceptively simple trick for any lawyer. If you really want to elevate your writing to the next level, use a strong subject verb cluster, meaning a strong subject, ideally an actor, an action verb, something that the subject can do, and keep that subject and verb close together. What I encourage you to start noticing in things that you write, either your writing or other people's writing, is that when writing is hard to read and it's hard to follow, the culprit is usually some form of passive voice combined with having a subject and its verb far apart from one another. And if you'll avoid that, that's gonna make your writing dramatically better than everybody you work with. And so we're gonna talk next week about power writing, and there are several things I'm gonna go through with you, but the number one is strong subject, action, verb close together. You would not believe what a difference it makes, and that's what he does here. The third thing he does is that he links things with transitions. Using the funds, the district paid. At the end of each day, the inspector prepared. After the data, the DPW prepared. So it's a combination of chronological organization, strong subject-verb cluster, and transitions between ideas. And that's why this is easier to read. And remember, we don't just want to know why, we don't just want to know that writing is good, we want to know why it's good. And judges in particular, really in the last 10 years, have gotten much better at writing opinions that are accessible to the general public. And this is one of the ways that they do that. It's just very clear, concise writing. It looks like, you know, like how else could you tell this? But it's a lot harder than you think. And if you ever want to try, if you ever really want to see how hard it is to describe something, try to explain to someone how to draw a triangle. But don't tell them you're telling them to draw a triangle. Just tell them you want them to draw something, and then try to give them instructions to draw a triangle. It's a lot harder than it seems. It's a lot harder than it seems. And so once it's constructed this way, it looks like it's obvious, but a lot of care really goes into writing this way. So he goes through the facts. He goes through what happened at the very end. At the close of the government's case, the district court dismissed 8 of the 15 counts. The final sentencing proceedings, the next paragraph, the resulting offense level, and then in Booker, here's what the court said. So here are the basic rules. So you've got everything there before you get into the 4 claims that he's made. So he starts this next section with, Broth's first contention is that the district court sentenced him in violation. Now, you already know there are 4 contentions and that none of them are going to fly. And so you know exactly where you are in this opinion. The next section starts with Broth's second contention. And the next section starts with his third contention. And then finally, his 4th contention. And then he goes through each of those contentions in the law and disposes of each one. And then at the end, wraps up by saying Therefore, there are no grounds on which to reduce or reverse this sentence. So it's a very logical opinion. The organization appears at the document level. It appears at the individual section level. It appears at the paragraph level. It appears at the sentence level. And that's really good logos. And if you've done your logos really, really well, then that also lends to your pathos and your ethos. It's rare that something that you do is one thing only. It's rare that it's just logos or just ethos. The other thing is, I showed you guys the super crappy redacted opinion. I did not show you guys that? Oh, you got to see this. It's not the opinion, sorry. It's it's a brief. Okay, so let me, because that's going to help you with logos, pathos, and ethos. It is a vivid illustration that I just absolutely love. I'm so sorry that I hadn't planned to show that to you. Okay, got it. Okay, well, I think what I'm going to do, because this is significant. This is something that'll be helpful. I'm going to load this on Twin real fast, and I want you guys to it's not going to take you long. Take about 5 or 10 minutes to just open it up and look at it. You don't need to print it out. Just look at it, and then I'll walk you through. I'll walk you through kind of the elements that are there. Hold on a second. So we're wrapped up with Garland's opinion. And so after we look at this brief, we'll look at Judge Kent's opinion. And actually, the brief and Judge Kent's opinion are sort of two sides of the same coin. The brief that I'm going to load, the title, it'll be under week 3, and the title will be Negative Ethos. And you'll notice that I redacted it, but not very successfully. And so I actually showed it to the person who gave it to me and said, I cannot get this to redact well. I mean, using magic marker, I couldn't get it to redact. And I said, is it still okay if I use it? And she said, oh, yeah, we don't care. The lawyer who wrote it was actually surprisingly a little bit, well, not even a little bit, was really very proud of it. Sorry, this is taking a little bit. I promise you this is worth it. Here we go. Okay, so it's under week 3, and it's called Negative Ethos. Take about 5 or 10 minutes to read through that, and then we'll talk about it. And I'll be right back. Has everybody pretty much read through it all? Okay, so let's talk about this. What do you think ultimately? Is it, if you were the judge, how would you rule on it? Yeah, Tiffany?
I think it was just very poorly written. Some of the things that he said, let me see if I could bring one up about it was very confusing. It was like, notwithstanding, hold on. I think it was section 2, plaintiff's counsel's protestations to the contrary notwithstanding, defendants have made a prima facie case showing. I just felt like that was confusing. And then section 4 was even, counsel asserts that the motion should be denied because I submitted his client's own medical records. I just feel like it didn't feel like a professional wrote it. It didn't feel like a lawsuit wrote it.
Okay. Other observations? Kyle?
I just feel like the author tried to negate the other person's arguments, but did a horrible job at agreeing with Tiffany. Like, he tried to discredit their arguments by calling them a crock or things of that nature, which really, you're just pointing attention to it, but not actually trying to negate what they're saying.
Yeah. Catherine?
Yeah, I was going to say the same thing. I can't believe he wrote, what a crock. It was, his overall tone was so sarcastic that you didn't focus on the actual substance of what he was trying to say.
Yeah. There was one part where I think, if I'm remembering correctly, he even wrote something like, no. You, son?
I think his use of language is kind of offensive.
Mm-hmm. Okay. In what way is it offensive?
Because in page 2, he said, an exaggerating faker, and what a crock, counsel's a hyperbole. A lot of language choice is kind of offensive. So
yeah. John?
Yeah, I mean, I just feel it was just, I mean, he comes across as juvenile in a sense. He's pretty offensive in the way he's going about explaining his case and just certain things. And even the way that he capitalizes certain words, you actually notice that so much more so, and it kind of takes away from the actual substance of what he's saying.
Yeah.
As you read through it, I mean, he does make some decent points, but you don't even notice them because you're so focused on really how offensive it is.
Yeah, so I think that John really hits the nail on the head, which is that he actually does make some good points. Substantively, it's a good brief. It's a good brief substantively. And if you look at the 10 traits of, because remember we said that ethos, I told you guys that ethos breaks down into sort of 3 components, and that the first component is intelligence, and that breaks down into 10 traits, and the next one is character, and that breaks down into 5, and then there's goodwill. And so we actually, in advanced persuasion, we do quite a bit with this document, and we break it down and look and try to figure out exactly where it fails on the ethos, because the logo, it's got logic to it. It's well organized. It's a solid argument. It's got logic to it. It has got some pathos to it, actually, in the way that it's organized, in the way that it's laid out. But there's also a lot of negative pathos. But the biggest problem with this is a lack of ethos. And so what we did was break it down so we could figure out, well, where did it go wrong with the ethos? And so when you break it down into those 3 components and you look at all the traits, what you find is he actually nails every single trait of intelligence. That this is from the intelligence part of ethos, he nails every one of those traits. And then he misfires completely on character and goodwill. Just completely misses the mark on character and goodwill. And then likewise, he does great on logos, but completely misfires on pathos. So persuasion is one of those things where you can't be a little bit persuasive. You either hit it or you don't hit it. And once you've gotten a little bit unpersuasive, you've really kind of poisoned the whole document. And let me read this to you. I just got this in my box today. It's the, this is high-level dork reading. This is the newsletter of the New York State Bar Association Committee on Court of Appellate Jurisdiction. And there's a column in this month called If I Knew Then What I Know Now. And there's a woman named Cynthia Feathers who's an attorney for the Rural Law Center of New York in Castleton. And here's what she said. Early on, I found a nice niche in appeals, but it took years to learn many valuable lessons. When I worked at the State Attorney General's office, I wrote a respondent's brief filled with counterpunches and defensive retorts. The reviewer helped me see that the respondent can reframe the issues. The brief could affirmatively state why the challenge decision should be sustained. Learning to welcome such criticism helped me later when I became a solo practitioner and dared to share my drafts with colleagues and to seek to be mooted by others. So, her first point basically is, I thought my job was to punch holes and be clever about punching holes in my opponent's arguments. And, she had a mentor tell her, no, don't be defensive. Go on the offensive. Make your own arguments. It took years at the AG's office and a few CLEs listening to appellate judges to learn the importance of not showing attitude in briefs. To this day, if my first draft are sometimes tainted by attitude, a goal in editing is to try to scrub away the heated anger, leaving only quiet logic. And so it is hard and it is tempting sometimes, especially when you are on the other side. And I certainly have this experience in practice. When you're on the other side of somebody who you don't think is very smart or who has been just a real jackass to you all the way through, that's going to happen to you a lot. And it's really tempting to try to, take them to task in front of the judge, but you can't do it. It just kills you. This particular motion brief was actually granted, but the lawyer was sanctioned by the court and fined, and also had to make a public apology to the opposing party, which hurt. That hurt. And also the judge required an apology to the court because the judge was so offended by what had been written. So that is a nice segue into Judge Kent's excerpts that you guys have. This is a federal district, or was a federal district judge. He no longer is. He's taken off the bench for different reasons. In the Southern District of Galveston, and he was on the bench when I practiced down there, but I was never in front of him. And so what do you guys think? Because, one of the things you learn in law school is that judges can do things that lawyers can't do. So here's a judge who's doing the same thing. What do you think? Tiffany?
I thought, ouch. I really felt for the attorneys because I was like, oh my God, if that was me, I'd probably cry. He was referring to their writing as like writing on the placemats with crayons and things of that nature. So I just felt really bad for the attorneys when I read it.
Yeah. What else? Any other observations? What did you think of the judge?
I thought he was really to the point and mean, but not mean, but hard-nosed.
Yeah.
I thought he was very hard-nosed and not taking any crap from anyone.
Yeah, that's true. What else? Other impressions of the judge? We talked about last week, we talked about the traits that we would like to see in a judge. Funny wasn't one of them. What do you guys think about that? Yeah, Catherine?
I think a judge can be funny, but it has to be at the right moment. I guess timing is everything. And I've seen certain opinions where the judge throws in kind of a dig or a sarcastic kind of, I don't know if it's a joke, but kind of a dig, but it's just the timing. It has to be right, and it can't be too often throughout the document.
Yeah. Yeah, in moderation for sure. Rob?
I was agree 100% with Catherine said. It has to be the right time and right place. And if you do too much, you can also show bias, I think, too. If you're too humorous, you might make it a joke and create a bias right there.
Yeah, I mean, that's one of the problems with this, is that it shows such a clear bias that, the judge isn't doing a very good job of seeming impartial, not doing a very good job of seeming professional, of seeming scholarly. It misses the mark on a lot of things. It's funny. There is no doubt that it is funny. And I remember when this happened, and it was funny. I still think it's funny, but that's not the job, So you have to be really careful. You have to be really careful. A rule of thumb for any kind of writing, is take the one sentence that you're proudest of and cut it. Because nobody else is going to get it. Nobody else is going to think it's as clever as you do. And likely it probably goes over some line. So take your favorite sentence, the one that you just think, oh, this is great. Take it out. Take it out. I do that with everything I write, and I've never been disappointed with the results. I hate to do it sometimes, but I've never been disappointed with how that turns out. So, yeah, again, he has a point here. I mean, the attorneys behaved unprofessionally, and they submitted documents that were unprofessional, but his response was to be unprofessional in return. And so you want to keep in mind, as you sit on the bench, that your job is to always be above the fray, and not to sink to them. Okay, so now we're going to start moving into Shuttlesworth, Walker, and Broomfield and Clark. So we've talked about the fact that that judges do persuade, that part of their job is to persuade, but their job is to persuade in a way that at least appears neutral. And we saw Judge Garland do that very well, and we saw Judge Kent do that not well at all. And so we want to look at these two opinions, Shuttlesworth and Walker, as a pair, and talk about the persuasion that we see there. So I want to start with those first few questions. I'm going to take a volunteer. Who would like to answer questions for the first part of this discussion? Okay, Jacqueline? So the first question, what are the dates of the respective opinions?
March 10th, 19, and June 12th, 1967.
Right. So, March, what did you say on the year? I remember it, but I don't have it in front of me. Oh, there we go. I've got it. March 69.
1960.
Yeah, and then June 67. Okay, so Walker comes first, and then Shuttlesworth. Who authored each opinion?
Judge Stewart.
Yeah, Judge Stewart authored both of these opinions. How is the story told differently in each case? So, for example, let's start with talking about the protesters. What kind of language did Justice Stewart use in 1967 to describe the protesters?
I'm sorry, my internet's skipping, so I didn't hear. How did he just describe the protesters?
Yeah, how did he describe the protesters?
In Shuttlesworth, he
No,
spoke
we're gonna
about
start
them.
with Walker. Start with Walker.
Oh, okay, sorry. In Walker, he spoke about them as like respondents and petitioners. He didn't actually label them anything other than what they are in this specific case.
Okay. And how did he describe what they did? Or how did he describe them specifically? Beyond the labels.
He started off. Okay. He started off the case by describing exactly what the demonstrations were,
Mhm.
what they were planning,
Mhm.
and what they had gone through, how they applied to do what they were doing. He spoke about them very like neutrally in Walker.
You're looking at Walker?
No, I'm sorry. In in Walker, he like accused them. He's like he spoke about them as if they were guilty. That's why it was very confusing to read both and realize that it was the same judge.
Mm-hmm.
It's the same exact case, same people, but in one he's being neutral, and in the other he's completely negative.
Yeah. And so some of the language that he uses, did anybody note any of the language that he used to describe the protesters or to describe the protests? Yeah, Catherine?
In Walker, he used deliberately defied, disobedient, violent, disorderly, unlawful.
Yeah, and he described them as a mob. So they were congregating in mobs. What about Tiffany and Shuttlesworth? How did he describe them?
In Shuttlesworth, he kept reiterating that they were churchgoers, that they were peaceful, that they obeyed the traffic laws, that they didn't obstruct traffic, that they didn't obstruct the sidewalk. I felt like that kept being reiterated throughout the beginning of the opinion.
Yeah, and he when he talked about it in the second paragraph of the beginning of it, it just says, on the afternoon of April 12th, Good Friday, 52 people, all Negroes, were led out of a Birmingham church by 3 Negro ministers, one of whom was the petitioner. They walked in an orderly fashion, 2 abreast for the most part, for 4 blocks. The purpose was to protest the alleged denial of civil rights. The marchers stayed on the sidewalks, except at street intersections. They did not interfere with other pedestrians. No automobiles were obstructed, nor were traffic signals disobeyed. The petitioner was with the group for at least part of this time, walking alongside the others and once moving from the front to the rear. As the marchers moved along, a crowd of spectators fell in behind them at a distance. The spectators at some point spilled out into the street, but the street was not blocked and vehicles were not obstructed. Compare that to respondents had sponsored and or participated in and or conspired to commit and or to encourage and or to participate in certain movements, plans, or projects commonly called sit-in demonstrations, kneel-in demonstrations, mass street parades, trespasses on private property after being warned to leave the premises by the owners of said property, congregating in mobs upon the public streets and other public places, unlawfully picketing private places of business in the city of Birmingham, violation of numerous ordinances and statutes of the city of Birmingham and the state of Alabama. It was alleged that this conduct was calculated to provoke breaches of the peace, threaten the safety, peace, and tranquility of the city, and place an undue burden and strain upon the manpower of the police department. It didn't even sound like the same thing. Like in the first one, like the first one makes me want to talk very, very quietly, so as not to disturb them in their meditative walk. And the other one makes me want to take cover, makes me afraid that somebody's going to throw a Molotov cocktail at something. So the stories are very different. What techniques are used to tell the stories differently? How do they achieve that, telling the story differently? One way that we've identified is that they characterize the group differently. A mob versus 52 people led out of a church by ministers. What else? How else does Justice Stewart accomplish a different story? Yeah, Tiffany?
I think he used logos in the way that he organized it differently in both stories. In the first story, it was more of a play-by-play of how he used the facts, exactly what they did in Shuttlesworth. They marched this, they did that. In Walker, it was more like they just had a disorderly march. That's it. Like, they just obstructed the law. And then I think word choice was a big one in how the stories were told differently. When he was referring, like you said, like to the mob and disorderly, as opposed to they just left church and they were peacefully marching, and those kind of words were used. And I noticed in Walker, like harsher words were used.
Mm-hmm.
And again, with the facts, he emphasized the facts in Shuttlesworth,
Mm-hmm.
but in Walker, he downplayed some facts. Like, he downplayed the fact that they did apply for the permit, I believe. And in Shuttlesworth, that was on the forefront.
Mm-hmm.
So I saw how he switched that. And then when he used like certain metaphors, like they applied plastic surgery to the Constitution in Shuttlesworth to show that they're making it what it's not to be. And he referred to the state officials as inferior in Shuttlesworth, but in Walker, they were more respected. So he gave them more deference. So that's what I noticed.
Yeah. What else, guys? What else did you see? What about the source of the information? What do you notice just at the very beginning of both opinions about not just the language, but the source of the language? What do you guys make of that large block quote in Walker? Because you have to assume that professional writers do everything they do for a reason. And so one of the things that's valuable about looking at these opinions side by side is that you do away with some of the excuses people make for how things are written. So, for example, you might say, well, sure, he was more forgiving on the actions of the protesters, but that was a different kind of situation. But these are the same situation. Well, yeah, it was the same situation, but this is a different judge who has a different style. Well, it's the same judge. So the differences are purely attributable to the result that he wanted to get to the first time versus the result he wanted to get to the second time. So you can assume that the differences between these two opinions are calculated to get to the result. And so any differences are on purpose. So what do you make of this huge block of quoted text? Yeah, Tiffany?
I hate to hog all the video time.
You're not hogging it. Nobody else seems to want it.
I was thinking about this as I was reading the cases, and I did highlight the block quotes, and it like brought me back to moot court. And I was thinking, is he using the briefs from either party? Like, is he taking the facts that he wants from a certain party's brief?
Mm-hmm.
And that's why he's reaching different conclusion and the language sounds so differently. So I was thinking maybe the block quotes came from a brief.
Well, where does that first block quote come from? I mean, it tells you exactly where it comes from. Who wrote that first block quote?
The circuit judge?
No. Look at that at the very beginning of the opinion. On Wednesday, April 10th, 1963, officials of Birmingham, Alabama filed a bill of complaint in a state circuit court asking for injunctive relief against 139 individuals and 2 organizations. Now notice also in Walker there are 139 people, and somehow in Shuttlesworth 2 years later there are only 52. Against 139 individuals and 2 organizations. The bill and accompanying affidavit stated that during the preceding 7 days, the city of Birmingham wrote that. And it's not from the briefs, it's from the complaint, the criminal complaint. So they lifted the facts out of the criminal complaint. But the effect, instead of making it seem like it's biased, the effect is, because you guys read it, and you read it for class, you read it to be questioned on it, you read it to analyze it, and you just skimmed over it, right? So somebody who's just reading it to kind of understand the result at the end and isn't studying the document may not even pick up on that, where it was from. But it makes the facts look more credible. It makes it look like Stewart is just, listen, I don't make up the facts. These are the facts. Look, I'm quoting. These are the facts. And so he's able to distance himself from it and say, look, I don't have any bias against any of these people that are involved. This is just what happened. I'm just explaining to you what happened. But then 2 years later, same incident, and he wasn't interested anymore in that. So that's really interesting to me that he drafted the facts in the second one, and he got the other one from the Bill of Particulars. The other thing is, notice how the story is told as far as how it's sort of the perspective. The first one, you've got the officials of Birmingham. The story starts with them filing a complaint, which means they're going to be your main focus. Whichever character you introduce first is almost always going to be your main focus. It's the one that we're going to try to identify with. That's just how we relate to story. We get introduced to the first character, and we have been trained through years of reading, literature, television, movies. We've been trained to associate ourselves with the first people that come into the story. So here, the first people that come into the story are the city of Birmingham, just trying to be the city of Birmingham. And then these horrible people come in and start stinking up the place with their protests and their being in the street and being, they're sitting and they're kneeling and their parades and their trespasses. And so you've got the city of Birmingham just trying to do business as usual, and you've got these people coming in from outside of Birmingham to make a stink, to really make a fuss, and to disrupt what's going on. Whereas in the other one, you've got peaceful protesters being led from a church by ministers. And then you see the next paragraph. At the end of the 4 blocks, the marchers were stopped by the Birmingham police and arrested for violating Section 1159 of the General Code of Birmingham. So it's completely flipped. You start with the protesters, and then their program is messed up by someone else. And that's one of the easiest ways to set your story up so that your reader is sympathetic to the party where you want the sympathy. So you start with that person in equilibrium, and you show them being disrupted, and then you sort of leave the case as sort of if you're briefing the case, you leave it as sort of a cliffhanger. If you're the judge in the case, you show equilibrium, disruption, and then you use the analysis to restore equilibrium to the winning party. And you can do that. You can do through organization what you can't do through express words. If you indicate clearly who it is that you want to win, it's going to come across as very biased and very partial. And as you guys have seen in some of the things that we've read, that it just doesn't work. It's just not effective. You can't push your reader to the conclusion. You have to lead your reader very subtly to the conclusion. And these two opinions do that. And so that's one thing that you want to think about when you write your opinions. And it's what you want to think about when you read the briefs. You want to think about how does this story get told so that it gets to a result that makes sense to me. Okay. Now remember, you guys are going to have a post-argument conference, and that you can come into that conference completely open-minded, but remember, you've got to get a majority. Somebody's got to get a majority. You cannot hang up on this. And there are 13 of you, so you can get a 7-6. And you must get 7 votes on one position. And so you want to think about that going in. You want to think about, how do I argue this to my fellow justices so that I can get more votes for my opinion? So your first advocacy job for these cases is going to be to persuade your fellow justices. And to be quite honest, I think backdoor politicking is completely appropriate. I think if you guys want to talk about these things ahead of time and say, hey, where are you on these opinions? Maybe we can, maybe we're on the same page, or maybe we can compromise a little bit here. Maybe, I go this way on this one and you go this way on this one. That's completely up to you. Judges do it all the time. You guys saw that in the article. So we saw how the story was told, and remember what we learned in the Wald article was that the reality of how these things get decided is that the judges come to a decision, and then they sort of back into the facts and the law to bolster the decision and make sure that the reader is persuaded that the decision is correct. So that's the story that they told. And clearly the story supports the ultimate decision in each case. So now let's move on. Let's set that aside for a minute. What is the legal theory in each case? I asked you to be able to articulate in one sentence, what is the legal theory in each case? What is the claim in each case? Tiffany?
Okay, might be a long run-on sentence.
Okay.
I think it's on point. So for Shuttlesworth, I wrote, this case is about a state's attempt to use a statute that seems facially neutral to circumscribe the First Amendment protections of freedom of speech and expression afforded to all citizens in an attempt to discriminate against a particular group of citizens and the conveyance of their message in a public forum. And then...
So it's a First Amendment violation?
Yeah.
Okay.
the short end of it.
It's a First Amendment. That's the legal theory. The legal theory is the statute violates the First Amendment.
Yes. And then...
we don't even have to get into whether it's facial or whether it's as applied. We're happy with just, it's a First Amendment violation. That's the theory in Shuttlesworth. What is the theory in Walker?
For Walker, I put, I'm not going to say the whole thing, but I just put that it's a citizen's attempt to disregard the First Amendment, or to use the First Amendment to get away with murder.
It's a city ordinance violation.
Yeah.
Yeah. So you're absolutely right on the legal theory. You're completely 100% correct. You kind of went the long way around to get there. So yeah, so in Walker, what you've got is a description of an unruly mob that's causing problems in the city of Birmingham. And the legal theory is this is a city ordinance violation, plain and simple. They needed a permit. They didn't get a permit. and therefore we want an injunction to keep them from protesting any further. The legal theory in Shuttlesworth was a First Amendment violation, and the facts dovetail with that. This is a peaceful protest. They weren't doing anything wrong. They actually, well, in Walker it was they didn't have the permit. In Shuttlesworth they said, listen, they tried to get the permit and nobody would give it to them, and that's not right. And so you have a right to your First Amendment speech and freedom of assembly, whether somebody gives you permission to have it or not. And the Constitution always trumps some sort of city ordinance or statute. So these are orderly people trying to do the right thing, but who will not be hampered in exercising their First Amendment rights. So you see how the facts dovetail into the legal theory. How if you had the unruly mob and the First Amendment claim, it wouldn't make a lot of sense. Like if you handled it on that First Amendment basis, it would be harder, because even unruly mobs, as long as they're not, dangerous, are entitled to First Amendment protection. You can't quash speech based on viewpoint. So you couldn't get where you needed to go, even if you had the angry mob. Likewise, with the city ordinance, if you had the peaceful protesters who were who didn't have the permit, it wouldn't matter that they were peaceful protesters. They didn't have a permit, right? So there would be sort of a mismatch. And the problem with that is when you've got the unruly mob with the First Amendment violation, the result still has to be the First Amendment trumps city ordinances. But you've got an unsympathetic group challenging that. And so the result doesn't seem right. It might seem correct, but it doesn't seem just. Likewise, with the city ordinance, you've got nice people, but they didn't have a permit. And so nice people don't get different treatment than everybody else. So the result might seem right, but it still doesn't really seem just somehow. And so it's that dovetailing of your factual theory and the story that you tell with your legal theory that makes your result seem not just correct, but that makes it seem just. And that's ultimately what the courts are going for. What they're going for is results that are palatable, results that aren't going to garner a lot of criticism, because courts don't like to be the subject of a lot of criticism. It puts them in a sort of a difficult position. Particularly, trial courts and intermediate courts don't like to have results that seem unjust, because they've always got a higher court that can overturn them. And so that's problematic. So Shuttlesworth and Walker, same situation, same author, approached very differently based on what the result was and how to get there. And it wasn't just that the facts were written differently. It wasn't just that the law was written differently. The facts and the law had to be retooled together to get to that result. Okay. Are there any questions about Shuttlesworth or Walker, or the two of them together? Okay. So now let's move on to Broomfield and Clark, which I sometimes call Broomfield and I sometimes call Bloomfield for some reason. So Broomfield versus Kane. Somebody tell us what what the basic scenario of Broomfield was. And then we'll get into Thomas's dissent. Tiffany?
Broomfield was about a mother of, I think she had 6 children,
Uh-huh.
working 2 jobs to provide for her family.
Mm-hmm.
The second job that she took as I think it was for a supermarket,
Mm-hmm.
assisting the owner after hours to go to the bank. And during one of these trips, 2 men approached the vehicle, tried to rob them, and shot and killed them. The owner survived, but the police officer was killed.
Right. Okay. So let's fast forward now to Thomas's dissent. And we're looking specifically at section 1C. So Justice Thomas dissented. The Chief Justice, Justice Scalia, and Justice Alito joined as to all but Part 1C. And so they agreed with A and B, which we're not reading, but they wouldn't join the dissent in C. So let's see what happened in section C that caused several of the justices to say, oh, I really can't go there with you, Justice Thomas. What was section 1C about? What was the story that was told in 1C? Catherine?
Sorry. He focused on the victim's son, who ended up being very successful. He played for the NFL. He raised his family after his mother was killed. He worked for many charities. And basically what he was trying to say was, this person who was the victim here made a bad situation into a good one and didn't resort to the type of behavior that this criminal did. So
yeah, and so what was the contrast between the two? Give us some specifics. And one thing I didn't include in this, I don't know why exactly I didn't include it. I couldn't figure out exactly where it went in the opinion. I think it went at the end of Thomas's dissent, but I'm not positive, so I didn't want to cloud the issue with it. But if you look the case up on Westlaw, which I assume some of you did, you might have noticed that at the end of Thomas's dissent is a picture of the woman in her. Thomas included a picture of the mom in his dissent. I thought that was incredible. I thought that was really incredible. Like, he's really pushing the pathos here. He's really pushing it. So tell us, Catherine, about some of the contrast. Tell us a little bit about the defendant.
Well, they were focusing on his IQ,
right?
And how he faced challenges in his life where he didn't do well in school, and I think he had some psychological evaluations that, and he was. I believe they were talking about how they both came from like a bad area too, if I'm not mistaken.
Right. Yeah.
So how do 2 different people from the same background end up, one takes their situation and blames them, plays the victim and blames where they came from on their behavior, or their behavior, where they came from. And the other person is completely opposite. So they draw the sympathy for the victim.
Yeah, so they contrast this kid who had a 75 IQ, 4th grade reading level, some profound mental disabilities, some profound emotional disabilities, in addition, some adaptive disabilities, spent his years in school and special education, and by all accounts had no support whatsoever. And then in contrast, in the section C, Thomas talks about the son of the woman who was killed. This isn't the woman who was killed. This is the son of the woman who was killed, and he compares him to, and he goes, look, this guy grew up in a bad neighborhood, and his mom was killed. And he went on to the NFL, and it says while balancing football and family, he started homes for the holidays. He was inspired by his own mother, who spent years working toward the purchase of a home for her family. Dunn's contributions didn't end there. After joining the Atlanta Falcons, he expanded the reach of homes for holidays, traveled overseas to visit our armed forces, led an effort to raise money for the NFL to help respond to the tragic effects of Hurricane Katrina, involved in grief counseling services to children. I've told you guys before, you never miss with children. You never miss with children. Home for Service, a program dedicated to helping service members, police officers, and firefighters so he achieved home ownership. And so, his fundamental premise is, this guy could have, this defendant, Broomfield, he could have turned out this way. What do you guys think of that as a proposition? They came from the same place. Why did one become an NFL player and a philanthropist, and the other became a murderer? What do you guys think about that? Jacqueline?
I think what he was trying to get at, a lot of times people blame where they come from and their nature. Mm-hmm. And I think what he's trying to say is it was your own personal choice to be a bad person, because look at this person that came from the same place you did, had a horrible life, just made different decisions than you did. So
yeah,
it's
that is essentially the argument. What do you think of that argument?
From personal experience, me and my brother obviously lived the same lives, different roads. So I agree with the argument, but I don't think it should be in a court case. It's not a valid it's not a legal valid argument.
Okay. What about the rest of you? What do you think about that argument? Either the validity of the argument, just from a logical standpoint, or the validity of it as far as its appropriateness in a judicial opinion. Katie?
I personally don't think it's appropriate for a judicial opinion. I mean, I get the point he's trying to make and why he put it in there, but it's just not, one, there's no legal standpoint from it, and two, I think that it was very interesting that he would compare him to, a victim of the case. He could have compared him to anybody else.
Okay. Catherine?
Well, I disagree, because when it comes to sentencing, at least, they try to use some sort of logic as to why one person gets more than the next.
Sure.
As if motive doesn't matter, then I guess I agree. It shouldn't matter. So he's trying to point out the fact that it shouldn't matter either way where you come from or what you've dealt with. You still did the same crime. Everyone should get the same sentence. Mm-hmm. But that's not how it is. So he was trying to rebut the fact that this person shouldn't get any less of a sentence just because where he came from. I agree with it.
Okay. So you think it fits into, it fits legally into appropriate sentencing considerations, that it's a rebuttal of an argument that his background led to the crime.
Yes.
Yeah. Okay. Any other thoughts about the story? Chris, what do you think?
I guess I would kind of agree with what Catherine said. I can see the logical behind it.
Okay, Rob?
I was actually going to say I agree with Catherine, and I would definitely take that side.
What do you guys think about, okay, so if we look at it as a rebuttal argument, which I think is a valid way to look at it, we look at it as a rebuttal argument to the sentencing argument that, you know, his background led to this criminal behavior. And so Thomas is rebutting that by saying, look, here's a guy with the same background, and he went a completely different way. So clearly that argument is not, that argument is fallacious. If you were the defense attorney, what would your response to Thomas's rebuttal be? Yeah, Tiffany?
If I was defense, my response would be, Your Honors, this fact is irrelevant. They're two different people. They're two different two people don't react the same way to the same situations.
Well, wait a minute. What are the situations that they're in that are identical?
Well, not identical, but from an adverse, from like.
Well, no, but what are the parts that are identical?
So his mother was killed, so he suffered an adverse situation, and the defendant, I believe they said he had a low IQ, and he came from a poor, like a disadvantaged home, and I believe there was abuse. Let me see.
Well, let me ask you this: is having your mother killed at 18 the same as a lifetime of institutionalism?
No, I don't think so.
No, it's really not. It's really not. I mean, I would argue just purely from a sociological standpoint that these guys didn't have anything like the same upbringing. That's like saying that just because somebody lives on your street, that they had the same upbringing you had.
Yeah, exactly.
I know people who lived on my street who had very different upbringing that I had. In fact, my brother had a different upbringing than I did because we were 8 years apart. And so when he was 10 years old, I left for college, and he had same parents, but he had a very different path than I did, simply because he was an only child the second half of his life. So the idea that because you live in similar neighborhoods, that you had the same upbringing and the same opportunities. The other thing is, this kid had an IQ of 75. 100 is an average IQ. And I actually had several clients, criminal clients, who had IQs between 60 and 80 at different times. And it was very hard to communicate with them. It was extremely hard to communicate with them. And I will bet you every cent I've ever made that not one of them graduated from Florida State. So they're very, like, the rebuttal to that argument is, wait a minute. Those aren't the same paths. Now, I think it's still an argument you make as it's a prosecution argument that, hey, everybody has bad circumstances. Everybody doesn't end up, killing somebody. And I think that's perfectly valid. But I think this argument isn't necessarily logical. Like, I think that argument is logical. I think this particular illustration of that argument is maybe not as logical. Okay. So then we look at Alito's exception to the dissent. And he says, I join all but Part 1C of Justice Thomas's dissent. The story recounted in that part is inspiring and will serve a very beneficial purpose if widely read, but I do not want to suggest that it is essential to the legal analysis in this case. So he's saying, no, this has no legal value. This has no legal value whatsoever. So he would reject the argument that some of you made, that I think is actually a good argument, that no, this is the kind of thing that's relevant to sentencing. This is a good rebuttal. He's not saying this isn't the right illustration. He's saying no illustration here has any legal value. Okay. So Broomfield was decided on June 18th last summer. Also, or announced on June 18th. Also announced on June 18th was Ohio versus Clark. And so if we look at, I told you to look at the first paragraph, but we can go ahead and look at the first two. Justice Alito delivered that opinion. Okay, so he's already said, I don't like stories. I don't like stories. I want to focus on the law. I don't like stories. Let's keep it relevant. So here we see that the issues in Clark are that, first of all, the holdings that the 3-year-old victim statement was not testimonial, and that the Ohio law that barred incompetent children from testifying did not make it fundamentally unfair for a trial court to admit the 3-year-old victim statement. So this is purely an evidentiary issue based solely on the statement that the kid made to his teacher and the admission of that statement in court. That's it. Those are the issues. So you would expect then that Alito would stick to the circumstance where the kid relayed to the teacher what had happened and the introduction of that in court. What he steps off with, though, is Darius Clark sent his girlfriend hundreds of miles away to engage in prostitution and agreed to care for her 2 young children while she was out of town. It's not relevant. It's not relevant. It doesn't matter why. None of that matters. None of that matters. A day later, teachers discovered red marks on her 3-year-old son, and the boy identified Clark as his abuser. So you could say that he was in the care of Clark and that the kid identified Clark as an abuser to the teacher without saying that Clark sent his girlfriend 100 miles away to engage in prostitution. The next paragraph, Darius Clark, who went by the nickname D, lived in Cleveland, Ohio with his girlfriend Titi and her 2 children, and these are abbreviations for confidentiality. LP, a 3-year-old boy, and AT, an 18-month-old girl. Clark was also Titi's pimp, and he would regularly send her on trips to Washington, D.C. to work as a prostitute. He has now, in 2 consecutive paragraphs, said this dirtbag sends his girlfriend hundreds of miles away to engage in prostitution while he stays home with those kids. It's not relevant. It's not legally relevant. So what do you make of the fact that he didn't like Alito's, he didn't like Thomas's use of the story, even if it's arguably maybe relevant? He said, no, it's not relevant at all, and felt so strongly about it that he didn't just say to Thomas, separately, I wouldn't use that story. He on the record said, this is not relevant. This is not legally appropriate. And then in a decision announced on the same day, led off with this information. What do you make of that? You have to explain that to yourself somehow. Alito's a smart guy. He's a smart guy. He's an analytical guy. So he's not just being crazy. What do you make of this? Katie?
I was thinking that since he's the main one writing this opinion, that he wants people from right off the bat to think that Clark is a bad person and that, so let's start off with that he's a pimp and what he does and that he beat the children. And then that way it just sounds better, even though it's not legally relevant.
But he's already said, to Thomas's opinion, I don't like the stories. I don't like the stories that aren't relevant.
I don't know, maybe because, I don't know, I just think that it makes the opinion sound, one, more enticing, and two, it makes it sound stronger even though they're not relevant.
Okay. Jacqueline. I have a Jackie in the other class.
It's okay. I think when I read this was judges do what they want. They do what they want when it's and they're going to say what they want when it's and in the previous case, the story it didn't help. I agree with it, but it's a little much. So in this, he's trying to keep it, like he keeps mounted too much detail.
Mm-hmm.
He just keeps harping on that detail because it helps his argument.
Okay, that's a great point. Melissa, what do you think? If he only likes legally relevant stuff, why kick this one off without legally relevant stuff? Hold on, Melissa, we can't hear you. There you go.
I kind of agree with Caitlin said before, that he just wanted to make him look like the bad guy.
Mm-hmm.
Before he renders his opinion. And that's why he said that.
Okay. Kyle, what about you?
I kind of agree with what Jackie said. He kind of, judges a lot often use things that are in their favor when it's beneficial to them, but then at other times they're oh, we don't like to do things like that, but I'm going to do it anyways because it helps me.
Yeah, so I think you guys, you really have all nailed it on the head, which is, in principle, he doesn't like it. He thinks it's dirty pool. He doesn't want to be persuaded by it. But he clearly recognizes the value of it because he uses it himself when he's trying to persuade. And so I think what we learned from reading these two excerpts together is that for all the lip service judges give about only wanting to be swayed by logic, they clearly recognize the value of story. They clearly recognize the value of making the narrative support the result. And that when they do their own writing, that's what they do. Okay. Any questions at all about persuasion generally or persuasion in opinions? So what I hope that you guys got from the stuff that we covered this week as we move ever closer to the opinions that you will draft is that these tools of persuasion are something that you can use and should use. That once you have a majority that you have to write, and of course, you don't have to be in the majority on these opinions to write a majority opinion. You have to write two majority opinions, whether you're in a majority or not. Which means you're going to have to write something that supports the majority result, whether you believe it or you don't. And so these techniques are particularly helpful in that situation. They're also really helpful when you're in the majority, but maybe you didn't love the reasoning, and so you've got to maybe shift around how you think about the facts to make it fit the reasoning that the majority wants to go with. So hopefully you've discovered that drafting the opinions, it's more than just the pure exercise of identifying the law, applying it to the facts, and coming to a result and then writing that out and publishing it, that there's a lot of compromise that goes into it. There's a lot of persuasion that goes into it. There's a lot of politics that goes into it. And so it's not as pure of an endeavor as maybe we would like to think that it is. Any final observations or questions? Yeah, you, son?
I just wanted to ask you about this story telling in Ohio versus Clark. What do you think about I just want to ask your personal opinion.
I think it's effective. I think it's very effective. I don't know that you need it necessarily. I mean, you know, the fact that the fact that the teacher was an outcry witness, like, that's pretty compelling on its own. It's a 3-year-old with bruises talking to a preschool teacher. That's pretty sympathetic. I don't know that you need the nail in the coffin, but I can kind of understand why you might want it. I didn't think this was any more appropriate than what Thomas did. I thought they were both a little too much. But sure, like, once you know that this guy sends his girlfriend away to be a prostitute and he stays home with her kids and abuses them.
Yeah.
I pretty much don't even need to read anything else. I'm like, oh, well, maybe he didn't do this, but he did something. Lock him up. So, which I think is kind of what the judges want. So it's funny that, Alito clearly felt manipulated by the story in Thomas's opinion. And I have to admit that I feel a little bit manipulated by what he did in Clark. I think it's interesting that it's just the power of story and the power of narrative. It is just too much to resist, because as writers, we know it's going to work. We absolutely know it's going to work. And so it's just too much to put back. Rachel?
I actually had the same question as you, son. So I just lowered my hand.
Okay. Okie doke. So next week we're off again on Monday. So we are only going to meet on Thursday next week. And when we do that, we will talk about power writing. So we'll go through a revision technique, and then putting together the material we've covered on persuasion with the material that we're going to cover on revision next week. Then I'll give you your judicial opinion, the revision opinion that you will revise for one of your projects. And so that way you can get a little bit of practice with revising an opinion before you have to work on your own. Okay. Okie doke. Have a great weekend. I will see you guys next week.